Welcome. Industry program has been brought to you by MAMI in collaboration with our festival community partner, Soho House Mumbai. So yesterday we had a look at contracts. We talked about film contracts filmmakers need to be aware of. And in continuation with our legal series, today we turn the spotlight on IP, and copyright infringement. And with us to talk about this is Akshat Agrawal. He is a practicing lawyer at the Supreme Court of India. He works in new media and technology as well as IP. Over to you.
I'll be talking mostly about what kind of rights do filmmakers, and I'm mostly going to be restricting myself to filmmakers today, what kind of rights do filmmakers have, and what kind of sort of enforcement strategies they can take if they come across something that's likely copied from their work. So what all things they need to do for that, and what kind of remedies they can expect out of a court of law or in a negotiation, what kind of sort of strategies they can have. I'm not going to be talking about contracts and about what kind of agreements you need to have with the production companies, etc., because I think that was taken care of yesterday. So just to give you basics about the kind of work that I have done in the past. I worked on the 2012 copyright amendments with the firm that I'm associated with right now, who sort of spearheaded those amendments to make sure that people who are working in the industry as authors, singers, performers also get their due. So that's something which we have worked on for a while. And in that context, I would like to sort of begin, and I'll make it short so that we can have a lot of time for Q&A. I'll begin by just mentioning the kind of rights all the filmmakers or musicians or people who are involved in the creative process have. So copyright essentially provides every one of us a bundle of rights. You don't need to register anything. There's no need to approach a government functionary to get any right per se. You have it. As soon as you have created something which involves some judgment on your part and you have put it down on paper, you have a right. Right. You have a right over it in terms of others who have access to it cannot imitate it, in the sense it cannot be verbatim copy or something trivially similar copy to that particular output of yours. And we'll talk about it as to what that means. But the kind of rights you get out of this whole putting things on paper idea is fourfold. The first being, no one can reproduce your work, meaning no one can, without your permission, make a copy out of it for exposing it to someone else, or make something substantially similar. We'll talk about what that means, but yeah, that's the first thing. Second right that you have as a filmmaker is that no one else can adapt your film into a book, for example, reverse psychology, right? Book to a film, film to a book. Or no one else can adapt your film into some other medium of representation, like a drama, like a theatrical exhibition, right? So you cannot do that unless they get authorization from you. The third set of right is that you are the only one who has the right to showcase your film to the public. No one else can, right? That's the third right, communication to the public. And the fourth right is the right to issue copies. So only you can issue copies of the film to someone else, right? To sort of, for example, you're a film producer, you're issuing copies to theaters to sort of exhibit it, right? That's the set of rights that you have. What are the scope of those rights? We're going to get into that. But very importantly, as a filmmaker, as a director, for example, you don't get any rights. All your rights are sort of dependent upon your agreement with the film producer. So section 17 of the Act says that all the rights vest with the film producer. And it's there that, there are a few exceptions for those who are actually involved in the creative process. There were cases concerning the role of the principal director of a film, but nothing worked out in their favor. So, for example, UK has a specific provision for principal directors being authors, whereas in India that's not in place yet, and it's the film producer who gets everything, and then you sort of negotiate with them to get your share of the pie. So, importantly, Section 18 and 19 of the Copyright Act were amended in the 2012 amendments that I just mentioned, where a compulsory royalty mechanism was created. Helped the musicians a lot, because all the musicians sort of now have a piece in the pie where they can approach IPRS as a society to sort of negotiate on their behalf and get royalties out of film producers whenever their music is shown in a film, right? That's a big breakthrough sort of amendment. Something similar is doing the rounds right now in discussions and negotiations for principal directors of films as well. Now we come to the meat of the matter, which is Section 51 of the Act, which not many people who are in the industry would be generally aware of, because unless you get to the stage of litigation, that section has no relevance, which is the section concerning infringement. You barely get to that because you already sort of negotiate a dispute prior to that, but in case you have to sort of build your negotiating power and understand what is actually infringing your right under the law, you need to understand what Section 51 means. And what that means is that no one else can infringe upon any of your rights in 14, the reproduction, distribution, communication to public, and adaptation right. And no one else can permit a place for profit where such infringing activities are taking place. These are the two set of rights you get under 51. 51 is primarily dependent upon one doctrine. And that's just everything I'm here to explain you guys. That's all I'm trying to sort of explain to you today. That's the substantial similarity doctrine. There's a difference between reproduction and making a copy. Reproduction means where I am sort of producing the same thing again. It's a relative sort of a thing where I'm producing another work which is similar to a previous work. Making a copy, on the other hand, is just making a copy of that work, in the sense physically reproducing it, that particular work that exists. Everything to be able to get copyright in the first place requires two things. Skill on the part of the person creating something, but that's not enough. So there has to be multiple options out of which you exercise your judgment, and that judgment, that detailed judgment, is what gives you that fulfills the originality requirement for you to be able to assert the right. Coming to the doctrine. What is this? The doctrine of substantial similarity defines the scope of your right. What exactly do you have when you say that I have copyright over this? Let's talk about cases, and some interesting ones. The best one, the most important one in India, at least for everyone to know of, and I know you guys wouldn't be able to be exposed to these cases because these only come at the litigation stage. But it's generally good to be aware of these cases because you sort of know the scope of your rights through them. So the most important one, you see New Delhi over there? That's the R.G. Anand versus Deluxe Films Supreme Court judgment. The Supreme Court, the only Supreme Court judgment on films and copyright law. And it's concerning this play called Hum Hindustani, which was sort of written by a scriptwriter who had sort of done this play. He had sort of, spoken to a few film producers about, Deluxe Films in fact, about being able to adapt his theatre, his play, into a film. He went to them, he spoke to them, he showed his play to them. They even sort of, entered into negotiations with him, and they did not proceed with the adaptation. Later on, this guy R.G. Anand, he gets to know that, well, they released a movie called New Delhi. And when he saw the film, he thought that, it seems like all of the character developments that I had created, all of the plot structure that was in my mind, the message that I was trying to convey was actually in that movie. And that guy did see my movie, did see my theatre, right? So this movie is actually an adaptation of my theatre. And so he went on to the district court in Delhi to file a case. He lost. Why he lost? I'll just get to it. But he lost at the district court stage, he lost at the high court stage, at the Supreme Court stage also he lost. And why did he lose? He lost because this case developed the most important doctrine in copyright law, which all of us have sort of based our creativity on. The distinction between idea and expression. The distinction which sort of allows us to understand that what is protected is not themes, plots, or concepts, or the idea of rags to riches, or the idea of a mother-in-law and a daughter-in-law fighting. Those ideas are inherently not protectable. What is protectable, on the other hand, under copyright law, under the scope of rights that a person gets, is the detail that you put in. Because that detail is the embodiment of your judgment. As against you picking up a vague idea about a patriotic film on India, specifically in the context of Delhi, and bringing it about for the public with a few character developments that can only be built in a particular number of ways. So this case was the hallmark developer of the film industry in India because it was a 1976 case. It created the basic idea of copyright law saying that what we protect are not broad themes or plots. What we protect are specifically detailed expressions. And so unless those specifically detailed expressions are encapsulated in the subsequent work in that detailed manner or with trivial variations which are nothing but a colorable imitation, just to, fool you, it won't be infringing. And that was sort of the build-up to the whole creative industry the way it has been today. So that's R.G. Anand for you. That's the basic case that we sort of talk about every time we come across a case concerning rights holders versus alleged infringers, sort of trying to figure out whether there's any kind of infringement and whether the work has to be injuncted, in the sense, removed from circulation or not. The other interesting case that came about, which sort of diluted this case, this judgment, was a Bombay High Court judgment, in fact, in a music context. It was the Crazy 4-1, Ram Sampath versus Rajesh Roshan. So there was a very interesting advertising sort of jingle called The Thump, which Hrithik Roshan was sort of acting in, and that music was created by Ram Sampath. He sued Rajesh Roshan for including a similar sort of a musical line in a song that he sort of composed for the film Crazy 4. The court diluted the R.G. Anand test and said, when we are talking about similarity between two works, we are not talking about them being similar in the sense of their quantitative similarity, in the sense, okay, how many elements are similar? That's not what we're talking about. We're also talking about that, but we're talking about something else as well, which is the qualitative aspect of similarity. Has the core of the work been picked up? In this case, there was only a 6-second sequence or that jingle that was incorporated, right? But that 6-second was the most influential second in the mind of the viewers, people who heard that jingle. That was the most attractive part of it. And so if that was ripped off for the court, that was enough, even if everything else was different. So that's the test being further explained to sort of tell you that when you are trying to say that something is similar to your work, it's not just the amount of similarity, but the portion, the qualitative essence of the portion that has been copied that matters, right? So that's the Crazy 4 case. Now moving on, through these cases we have had further developments and refinements in the law. The Barbara Taylor Bradford case. This case was a Calcutta High Court Division Bench case, which was concerned with this novelist, Barbara Taylor Bradford, who had written a novel called A Woman of Substance. There was a film that came out called Karishma, not a film, or a serial in fact, obviously acted by Karishma Kapoor itself. So that film was supposedly hailed as an adaptation of the book. Now the court, when it was assessing that infringement claim by Barbara Taylor Bradford, went into the details. It saw the film, it read the book, it sort of tried to sort of dissect what is there in the film and what's there in the book, and came to a realization that, come on, what is being copied is something which is being used by the subsequent creator to transform the work and make it a completely different work. So the court drew an analogy to a book as compared to the use of that book to create a guidebook. For example, in colleges, you guys must know that in colleges, you must be using this one guidebook thing which would have sort of encapsulations of all the subjects you're studying to be able to sort of pass that exam quickly, as against the whole textbook, right? It's like that. The court drew an analogy and said, you are using a small portion of that book, but then ultimately what the message that the watcher, the audience of the film is getting is something completely transformed. It's completely changed. So let us clarify. The scope of rights of a person who claims copyright is limited to that work which is original to them, plus someone else imputing trivial variations in that work. If the subsequent work is transformed where the audience will get a completely different meaning or message out of it, it's not infringing. And that was the way in which Barbara Taylor Bradford lost that case. Right? These are all loser cases. None of these cases, apart from Ram Sampath, of course, have the plaintiffs won, have the people asserting copyright won. And I'm just making a case that that's been the reason why we have had so many stories. The other interesting case, Singardan. Now, Singardan and Loot case were two cases which came right next to each other. One by the Bombay High Court. Loot case was by the Delhi High Court. Singardan was by the Bombay High Court. At the same time, in the span of 2 days, diametrically opposite. Because Loot case was a case which sort of, where the Delhi High Court held, I think the name of the plaintiff's case was, plaintiff's work was Tikki Film or something, I'm not sure. And the defendant's was Loot case because it was concerned with a suitcase that was sort of, lost with a lot of important belongings, etc. Whereas Singardan was another case which is talking about this box, antique box in the house of a prostitute and how, it found life through it and stuff like that. And the other film also had a similar plot. Now, in this case and that case, there were a complete distinction, and that shows that the mindset of the court, in spite of R.G. Anand being there, revolves a lot around their perception of the film. It's the judge viewing both the films and thinking, okay, in my view, this is just a rip-off. Okay, no, in my view, it's just the theme is the same, that can be, but the actual message I'm getting from the two movies is separate. It's very subjective. Because the lay observer test, right? For you, a film may be a copy, for the other it may not be. And that's what happened in this case. In Loot case, the defendant survived. In Singardan, they didn't. Singardan was set aside later on. Because it was wrong. Because it was based on the premise that the theme of the movie of a box, an antique box being found in a prostitute's house, having a life in itself, and being the most important thing, is copyrightable. But the court held it's not. It's not sufficient detail enough for anyone to have an individual right over it. Right? So that was that. Two interesting cases that I'm working on, one of which has just gotten over day before yesterday, and one which is sort of going on right now. One was the IC Kandahar case. Now that case, the interesting allegation of ANI, this news agency, was that there's a clip from a Vajpayee interview when the whole thing was happening, the hijack was happening, that you have incorporated in the film. Think about documentary filmmakers. They need such clips, right? They're using these clips to convey a different meaning or message to the public distinct from the clip itself. The meaning that has been conveyed by the clip or the purpose of the clip, that is to report news, is completely different from a documentary filmmaker's intent of using the clip to give a cumulative storyline to the public when they're watching a film, right? Do they need a license? That was the question before the court. Ultimately, the matter got settled because that's what they do. The last case that I want to talk to you about and that I'm dealing with currently, it's pending, is the Secret Couple. Now, this case is in the context of audiobooks. There's this audiobook platform called Pocket FM. There's this audiobook platform called Cuckoo FM. They produce really cringe audiobooks, and it's a mess for us because there are around 150 episodes in each of these platforms shows, and we have to sit down and listen to all of those audiobook episodes and compare them, make a table, Okay, this one says this one says the mother-in-law was pissed, that one says, oh, the mother-in-law was pissed, but this, So create differences amongst them. And all of the dispute boils down to these cases. R.G. Anand, Barbara Taylor Bradford, everything, every case in copyright infringement that happens today, relevant for all of you, or any filmmaker, any film director, is just based on these 6 precedents, nothing else. So once you know these 6 precedents, what will follow for you is that you will know, okay, I see this work, this looks like mine. Okay, should I go ahead? If I go ahead, I have this thing in the back of my head helping me, giving me some negotiating power. Or if you see, okay, it's not worth going ahead, but I know this, so I can sort of negotiate in spite of that. That's the mindset you got to keep, or you got to get your lawyers to keep. Because that's the only way you're going to survive. Unless you know what the scope of your right is, you're not going to be able to sort of enforce it. Right? So every case that is ever litigated in the film copyright sphere always comes to this, nothing else. So what can you do? Once you sort of prove that you are infringing someone's infringing your copyright, what can you do? You can get an injunction at the trailer stage. Sometimes it's tough to get a trailer stage injunction. But you can also get an injunction post the trailer stage. That is once the film is released. The court can prohibit the film from being released or being shown on any OTT platforms. You can also get money, you can get damages, in the sense compensation for that kind of use. You can restrain release. Importantly, Netflix, for the case, if in case there's a film, there's a show on Netflix that you think is infringing one of your works, Netflix is always a co-producer, so it will always defend every content that it has on its platform. Amazon Prime, on the other hand, is a co-producer in certain cases, but in certain cases it's a mere distributor. Like Amazon Prime also has HBO's content on its platform. There it takes a defense, what we call the intermediary defense, where it just says, okay, you tell me, do you think it's infringing? Okay, if you're telling us, we are going to take it down. Unless the person whose content is taken down comes up to us and tells, okay, we are not infringing. Then we put it back, and then you guys go take your fight in the court. Don't come to us. That's what happens, right? So that's something important for us to know as well. So yeah, I'm going to keep it short. I'm going to open up for questions. I know this was something which you guys may not have expected, but I thought it would be important for us to sort of know some things beyond contracts, especially about the scope of rights. So yeah, any questions now? I'm opening the floor for questions.
So it's basically a folk song, the rights to which are currently with a particular music label who's charging an exorbitant amount of money. But my understanding and my limited understanding is that folk songs are somewhat in public domain. So maybe I might not be able to get that, but can I recreate it? Like it's like Twinkle Twinkle Little Stars. I mean, you know, everybody knows it. Do I have to pay somebody to use
If you
that?
recreate a version of the folk song, and this is not legal advice, guys. I mean, I can give you legal advice if you want to reach out to me.
Yeah, I'm sorry.
But very generally, if it's a song that's a folk song, in the sense it's been in existence since more than 80 years, then you can obviously create your own version of it by making sure that that version that you create is not similar to any version that's not been existing since 80 years. Do you get my point? So you have a version of a song that T-Series has made another version of. They have copyright on that version. So unless that version, the parts of that version that are taken from the folk song are still in the public domain, but the parts of that version that are their own,
So like
they
if they
cannot be in
added some
yours.
lyrics, which is not the music, because the music is how the song anyway goes.
that cannot be in yours, and you're good.
Okay. Thank you.
Yeah. Not legal advice, huh? Yeah. Okay. Yeah, go for it.
Hi. So my question is again about adopting information which is already existent in the public domain and copyright related to that. So for example, I'm telling a story from 50 years ago, and it is about a person or a set of individuals. The information about their lives exists in the public domain. They may not be public personalities like a politician or an actor or a sports star, but regular people. Information about whom is existent in the
Are
public.
they alive?
They are all dead.
Yeah, then you can use it.
But these are very specific things to their life. Can their family come
Personality rights are not existing post-mortem. There's this case which happened with Sushant Singh Rajput called Krishna Kumar. His father sued, and the Indian courts have categorically held that personality rights die with the person who.
But what about the
Passed away.
family which files a defamation case about...
Cannot file it, right? Because if you're defaming them, that's a separate story altogether. If you're talking critically of them, that's a separate story altogether.
But in a story, there will be all points of views. I mean, you can always debate defamation. That's never a...
That debate you'll have to be a part of, right? If you're choosing that trade-off, then it's for you to be a part of that debate as to whether it's defamatory or not. So defamatory has a truth defense. So long as you can investigate and sort of bring out the fact that, okay, you are talking about someone's life and you're being truthful about it, they cannot claim a monetary aspect against you. They can claim a compensatory aspect against you through the family on defamation only. And defamation requires falsity. So that's something which you have to defend yourself against.
So I'm still liable regardless of...
If you do something defamatory, of course, right?
But then that is so subjective.
So yeah, fight it out. What are lawyers for? Yeah. Sorry.
So this is about when you're trying to adapt a short story or a novel of an existing writer into a script. At what stage do you buy the rights of the film? And I'm asking this because the scripts that I'm thinking of, they're not commissioned yet. It's not by a producer. I am thinking that I can adapt this book into a script. So should I, as a writer, go and buy the script, or when I'm
So you'll
pitching
be a
it to
script writer
Yes, yeah.
who'll be wanting to use a book, adapt that into
Into
script
a
writing,
script, yeah.
and then pitch it to.
Let's say a producer, yeah.
Yeah,
Then-
so I guess you should, once you're initiating writing a story basis that's book, either at that stage you should get the rights or at the stage of pitching it. So whenever you are indulging in something commercial, prior to that, it's advisable for you to sort of have rights, adaptation rights sort of taken from them.
And I have to get the rights, or the producer who's willing to put money on the
If
script?
they pitch, if the producer who pitches, who you pitch to, is willing to do that, so that's a part of your pitch,
Okay.
right? You have made a story, a script, basis the book, right? You did it without rights as of now. You're pitching it to the producer to see whether the producer wants to make a film out of it or not. Now it's that producer's added cost as to whether they would want to use your script and take the adaptation rights from them, right? So that's their call, and that's basically your pitch as to how your pitch is to them, right? If, on the other hand, you get clear the rights on yourself, then they have a lower cost, sort of a liability. The pitch may become easier, and then you can sort of later on, as a part of your deal with them, have this task that, okay, I got rights on that person when I created the script. Now you're making a film over it. Give me that valuation of the rights because I'm working for you, right? Because you're getting all the rights in the film that you're making, including on my script.
Okay, just to follow up on that, let's say if I don't take the rights and I write something and give it to the producer, but later on the writer refuses to give the rights, so then you cannot go ahead with the script.
You cannot go ahead with
Yeah.
the script unless the script is sort of transformed and change it. Yeah. Okay. Yeah.
Hi.
Hi.
You spoke about principal director and the royalty bit, which is in works. Could you tell
Yeah.
us at what stage it's at, and will it be something which cannot be assigned, even if?
No, everything is assignable. So we had this debate in 2012 as well, where we sort of were trying to make sure that the royalties of the musicians are not assignable. But I mean, we're in limbo, man. The way the market works is that everything which is a property right is assignable, and royalty is a property right as of the way it's sort of conceptualized currently. So it is assignable as well. Everything is assignable that way, right? So this whole principal director debate is coming up right now again. It came up in this Delhi High Court case, MRF versus Metro Tires, where coincidentally the judge who was sitting on the bench, his wife was a director. So he was, specially interested to explore the position. And we figured out that in the UK, principal directors are sort of treated separately, and they are given some claim in a film that is produced. In India, it's purely the producer because of the entrepreneurial sort of venturing. So there are amendments in talks going on. I'm not aware of the stage, but consultations are going on where at least law firms are being sort of, approached to figure out as to whether principal director should also be given a similar status as to how music composers were given in the context of songs, which are incorporated in a film.
But music composers, even they can't assign, right? From what I believe.
The royalty component, it's in the law, it's assumed to be non-assignable, but they still do end up assigning it away because unless they have an IPRS deal, because an IPRS collects it on their behalf. So that's a collective society where they have the power dynamic to do that. But when they do not, they still have to put it away. Yeah. No. Yeah.
I had a question. You mentioned that you cannot copyright ideas.
Yeah.
But what if I have an event, like for example, this session, the industry program, and I'm repurposing this event and I'm getting brands. I've struck a separate deal. Is there like
Nothing. No
nothing.
intellectual property right on it.
There's no intellectual,
No intellectual
and trademark doesn't come into play.
Trademark comes in the picture. You're using MAMI or Soho. You know what I mean?
Right, only then.
Yeah.
And also I wanted to ask you, you mentioned the preceding case law, the one that you worked on where you reused news footage.
ANI.
ANI, yeah. Isn't it like you are repurposing their footage for commercial use? Isn't that Can I just go use NDTV footage?
Very interesting point. So repurposing, that's the word you use, right? So long as the purpose is different, it's not impugning the intended market of the original work.
Did the producer have to pay any damages to them?
No, this case ended up getting settled.
Okay.
Unfortunately, we had 2 days of arguments and it got settled.
You had like a mediation.
No, I mean they just internally settled. It was
Okay,
Netflix was
okay.
involved. So that was what happened. But the argument was, when it was in court for the couple of days, it was that the purpose of use is completely different. It's like a book to a guidebook. You know what I mean? A book and a guidebook are not competing in the same market.